Hello UPSC warriors. Lost in the prelims maze? Fear not. Target Prelims is back and back for its 5th triumphant year. Get ready to slay those questions. We are serving up 28 days of prelims conquering power with daily 90-minute evening sessions at 7 p.m. starting today. Polity, economy, history, geography, you name it, we have got it covered. Now, you can pause the video and take a look at the comprehensive schedule to plan your revision like a pro. This is your chance to write your own UPSC epic. Let's begin. Now, the first 5 days, starting today, are devoted exclusively to discussing questions from polity. Now, what we have done is we have divided these 5 days into the various 5 topics that we'll be discussing over the course of next 5 days. So today, we'll be discussing questions from the topic executive, which will include president, prime minister, of course the vice president, governor, chief minister, council of ministers, as well as cabinet committees and a couple of questions on attorney general of India as well. Tomorrow we'll discuss questions from legislatures, that's the parliament, as well as state legislatures, and of course parliamentary committees. Day 3 will be devoted exclusively for discussing questions from the topic judiciary, which would include, Supreme Court, High Courts, the lower courts, then Lok Adalats, etc. Day 4 will be all about discussion on questions from fundamental rights, DPSPs, fundamental duties, preamble, etc. And day 5 finally is going to be on all the miscellaneous topics, including panchayats, municipalities, right, elections, Article 370, Schedule 5 areas, Schedule 6 areas, emergency provisions, etc. Right? So let's begin. First question. Which of the following are constitutional bodies? State Finance Commission, North Eastern Council, National Commission for Minorities, CCI, the Competition Commission of India, and the Special Officer for Linguistic Minorities. Now, it seems to be a easy question, I would say. A State Finance Commission, of course, is a constitutional body, Article 243, capital I. Constitutional bodies which are mentioned in the Constitution, they have a dedicated provision, an article, a clause for it. So SFC, right? This SFC is different from the other finance commission, which is under Article 280. This SFC is exclusively meant to deal with what? The panchayats and municipalities. And this body was, of course, added through the 73rd Amendment Act 1992 under Part 9 of the Indian Constitution. North Eastern Council is a statutory advisory body. It was formed through the NEC, the North Eastern Council Act of 1971. Statutory bodies are those bodies which are framed or established or created by an act of legislature. They are not mentioned in the Constitution. So of course, yes for this, no for this. The National Commission for Minorities, again a statutory body established in the year 1992, NCM Act. CCI, the Competition Commission of India, again a statutory body established in the year 2003 under the Competition Act of the year 2002. And finally, Special Officer for Linguistic Minorities, yes, it is a constitutional body, Article 350, capital B. This was added through the 7th Amendment Act 1956. So 1 and 5A is the right answer. Moving on to question number 2. Consider the following cases. Appointment of the Prime Minister when no party attains majority after elections to the Lok Sabha. Okay, exercising pocket veto, a temporary delay of an ordinary legislation even when the Lok Sabha has the confidence in the Council of Ministers, And number 4, dismissal of the Council of Ministers when it cannot prove the confidence in Lok Sabha. In which of the above cases is the President not bound, mind you, not bound by the advice of the Council of Ministers? Now see, as far as the President's power is concerned, in our country, he's rather known as, a nominal head. And that's again a part and parcel of our parliamentary system, nothing unique about it, right? So they also are referred to as sometimes rubber stamp, because ultimately they're always bound by the advice of Council of Ministers chaired by or headed by the Prime Minister. This advice was made binding in the year 1976. You can refer to Article 74 Clause 1 to find this information, right? But there are certain provisions wherein the President, he or she can exercise his or her power on his or her own discretion, on his own free will. No need to follow the minister's advice. So yes, whenever no party is able to get the majority in the Lok Sabha, then the President can call anyone, of course, from a party which has maximum seats to become the Prime Minister to form the government. So yes, this is correct. Exercising pocket veto, of course, is a discretionary power of the President of India. Why? Because nowhere in the Constitution is it mentioned that the President has to give assent to bills within a certain time frame. Time frame is not mentioned, which means what? There is absolutely no time frame for the President to give assent. He can keep the bill pending with him or her for as long as they want it. Take the bill, keep it in the pocket for as long as you want it. Pocket veto. Number 3, it's an interesting statement. A temporary delay of an ordinary bill or legislation, even when the Lok Sabha has the confidence in the Council of Ministers. See, second part was just to confuse you. Temporary delay in an ordinary bill. Now, can the President cause some delay in the passage of the bill? Yes, of course. What he or she can do is return the bill, right? The President does have the power to send back the bill. And what is that known as? That is referred to as suspensive veto, right? So, the President can use suspensive veto, but we know very well in India, ultimately, if the Parliament passes the bill again, the President is bound to give the assent, right? So yes, there can be a delay, but only a temporary delay. So here also, it's full on discretion. And number 4, dismissal of Council of Ministers when it cannot prove the confidence. Yes, at any point of time, if the Council of Ministers lose the confidence of the lower house, the Lok Sabha, the House of People, then it must be removed and the President can dismiss the Council of Ministers. That's true. So, right answer is D, 1, 2, 3 and 4. All these 4 cases are examples of discretionary powers of the President. Moving on to the third question. Which of the statements regarding the impeachment of the President is incorrect? Impeachment article is important. Article 61. This deals with the impeachment of the President. The process of impeachment can be initiated in either house. Absolutely correct. In any house. A 2/3 majority of the members present and voting in the house is required to pass the impeachment motion. Now, a 2/3 majority is required, but not present and voting. No. Of the total strength of the house. So this is what is needed. Total strength of the house. So this is incorrect. B is the right answer. Let's look at the other options as well. C, the President can be impeached for violation of the Constitution only. Yes, very important. This is a very important aspect. Ground and manner. Ground means reason. So what's the reason to initiate or bring an impeachment resolution against the President? Violation of Constitution. Very important point. And what's the manner? The manner is that this proposal, this resolution can be brought in any house. But yes, 1/4 members of the house need to approve it, right? Then in that house, discussions will take place, voting takes place with a 2/3 majority of the total strength. It is passed, sent to the other house, where again the voting takes place, and if the second house also passes it separately with the same majority, no concept of joint sitting, then the president stands impeached, removed on that very date on which the second house passes the resolution. Don't expect him to sign on the resolution. I mean, it will be embarrassing for him. You're asking him, sir, please sign on your own removal. That is not required. So C is also correct. And D, the president has a right to defend himself or herself through a nominated representative during the impeachment process. Yes, natural justice, you have a right to defend yourself. So that's also there. B was the only incorrect statement, hence the right answer. Moving on to the third question. Consider the following statements. Advice of Council of Ministers binding on the President. Fixing the maximum strength of Council of Ministers. Reduction in the voting age from 21 to 18. And obligatory on the President to give assent to constitutional amendment bills. What is the correct sequence of events from earliest to the latest? Earliest to latest. Now, advice of Council of Ministers made binding on the President when it was done through the 42nd Amendment Act of the year 1976. Fixing the maximum strength of Council of Ministers, this was done through the 91st Amendment Act of the year 2003. And what is the maximum strength of Council of Ministers, including Prime Minister? It should not exceed 15% of the total strength of the what? Lok Sabha. Reducing the voting age, of course, this was done in 1988, 61st Amendment Act of the year 1988, where the voting age was reduced from 21 to the current age of 18. And then obligatory on the President to give assent to constitutional amendment bills. This was done through the 24th Amendment Act of 1971. So we know very well the earliest event was this, number 4, then number 1, then number 3, and then number 2. B is the right answer. You can also simply mark B because this was the first event, 4 at the first position in only one option. Okay. Moving on to the next question. Consider the following statements. The Electoral College for electing the Vice President consists of all MPs only. It says all MPs only. Okay. So the Electoral College, the voter list, right, comprises of all MPs or only elected MPs. In the case of President, it comprises of elected MPs only, right, as well as elected MLAs, including MLAs of Delhi and Pondicherry. But when it comes to the Electoral College of the Vice President, then the MPs, all of them elected or nominated, are allowed to vote and only MPs are allowed to vote. Statement 1 is actually correct. Number 2, a person is limited to a maximum of 2 terms as Vice President. Now, there is no such official limit mentioned in the Constitution or anywhere. The person or any person can be the Vice President any number of times, no upper limit. Number 3, any elected MP or MLA can propose a candidate for the Vice Presidency. Now, you know, whenever you want to contest for a post, any post, let's say the President, VP, or even for MLAs or MPs, you require proposers, people who can propose your name, and then people who can second the name. Now, in the case of VP also, we need some proposers, right? 20 proposers are needed. But the problem is that the proposer can only be a voter. Non-voters cannot become proposers. So, in the case of vice president, who are the voters? Only MPs are the voters. So, who can propose a name for somebody who can contest elections or who can file the nomination? Only an MP can propose the name, right? So, elected MPs, of course, they can, but MLAs cannot propose the name. Sorry, because they are not what? They are not voters in the election of the vice president. So 3 is wrong. So which of the statements is or are correct? We know very well. A is right answer, 1 only. Moving on to the next question. Consider the following statement with respect to schedules in the Indian Constitution. Second schedule, third schedule, fourth schedule, 10th schedule. You know there are 12 schedules. The first one in this option is second schedule. What is second schedule? Second schedule deals with salaries and allowances, emoluments. What is third schedule? Third schedule is oaths and affirmation. So this should have been this. This should have been this. This means both are wrong. Fourth schedule, allocation of seats. Yes, absolutely correct. Allocation of seats to not the House of People, the Council of States, meaning the Rajya Sabha. So this is wrong. 10th schedule is anti-defection law. We know very well. This is correct. How many statements are correctly matched? What's the answer? A. Only one statement is correctly matched. We'll quickly recap all the schedules. What is schedule 1? The names of all the states and the UTs and their territory. Schedule 2 is salaries, allowances. Schedule 3 is oath affirmation. Schedule 4 is allocation of seats to the Rajya Sabha, Council of States. Schedule 5 is the administration of scheduled areas in 10 states. What is schedule 6? Schedule 6 is the administration of tribal areas in 4 northeastern states. Schedule 7 is the lists. Schedule 8, official languages, 22 of them. Schedule 9, immunity from judicial review. Schedule 10 is anti-defection law. Schedule 11 is what? Schedule 11 is list of 29 functional items on which panchayats can be allowed to make laws. And Schedule 12 is the list of 18 topics on which municipalities can be allowed to make laws. All the 12 schedules. Moving on to the next question, consider the following statements with regard to the Cabinet Committee, CCs. They have been established under the Government of India allocation of business rules. See, Article 77 Clause 3 says that the President shall make rules for the convenient transaction of business and also for the allocation of business amongst the ministers. So, Cabinet committees are formed under Government of India, not allocation, but transaction of business rules. Right? So, one is wrong. In fact, the ministries are found mentioned under the allocation of business rules. Okay. So, one is wrong. The Minister for Defence is the chairperson for the Cabinet Committee on Parliamentary Affairs. Yes, absolutely correct. Since 2019 itself, so prior to 2019, the Home Minister was the chairperson of this particular Cabinet Committee. But since June 2019, we have seen that the modification has been made. We have made a lot of changes. We have added some committees. 2 committees were added. And later on, the chairperson of this particular committee on parliamentary affairs, this task was given to, the role was given to the defense minister. So 2 is correct, 1 is wrong. Which of the statements given above is or are incorrect? Incorrect. A, 1 only, right? Reading the question is very important. Moving on to the next question, consider the following statements regarding cabinet committees in India and identify the correct ones. Okay, so they are extra constitutional bodies that derive their existence from the rules of business of the Government of India. That's correct. They are, of course, extra constitutional bodies because they are mentioned in Government of India rules. Correct? Not mentioned in the Constitution. Number 2, The Prime Minister has the exclusive authority to both appoint and dissolve all cabinet committees without requiring approval from the President of India. Now, see, the PM does have the authority, but without the approval of President is an extreme statement, because ultimately the President's formal approval is required, because these rules are made under the provisions of Article 77 Clause 3. So the President makes these rules. So a formal approval is needed. Hence it is wrong. Number 3. The CC on security is the only committee explicitly, clearly mentioned in the Constitution. These CCs are not mentioned in the Constitution, whether it's a cabinet committee on security, appointment, whatever, it is not mentioned in the Constitution. So 3 is wrong. Number 4. CCs are instrumental in reducing the workload of the Union Cabinet by dealing with subjects of a specialized nature. Absolutely correct. The real advantage of CCs is that they save the time of the government, the cabinet. So 1 and 4 only are correct. A is the right answer. Next question. If the Prime Minister belongs to Rajya Sabha, which of the following is or are likely to take place? Okay. He'll be allowed to vote if a no confidence motion is moved against the government. Yes or no? How can the Prime Minister be allowed to vote for an NCM if he belongs to Rajya Sabha? Why I say this is because Article 88. What does Article 88 say? Article 88 says that every minister and the Attorney General, mind you, both of them have a right to sit, speak in either house of the parliament and also be a part of any committee of any house. So yes, the Prime Minister, if he belongs to Rajya Sabha, he or she can sit in the Lok Sabha, sit in the Rajya Sabha, speak in the Lok Sabha, speak in the Rajya Sabha. But the point is, will he be allowed to vote in case of an NCM? Now, a no confidence motion can be brought only in the Lok Sabha, right? So, when NCM requires a voting, the PM can come and sit in the Lok Sabha, can speak on this topic, but he cannot vote because Article 88 does not give you the right to vote in any house. Your right to vote in the house comes from your membership of the house, right? So 1 is wrong. Number 2, he will enjoy a longer term than the MPs of Lok Sabha. Yes, of course. As an MP, he or she enjoys a 6-year term. Yes or no? The MPs of the Rajya Sabha have a tenure of 6 years. So 2 is correct. He will not be able to speak in the Lok Sabha during discussion on the budget. As I said, Article 88 allows ministers to speak in either house. So he can speak in the Lok Sabha, he can discuss on the budget, he can sit and watch the budget proceedings. But when it comes to voting on the budget, sorry, you can only vote in the house of which you are a member. So 3 is wrong. So how many statements are correct? Only 1. A is the right answer. Next question. Consider the following statements regarding the Attorney General of India. He is the highest law officer in the country and is appointed by the President on the recommendation of a 3-member committee comprising of the Prime Minister, Leader of Opposition Lok Sabha and the Chief Justice of India. Attorney General, Article 76. Attorney General is appointed by the President, yes of course, but it does not have the mandate of some kind of recommendation of a committee to be followed. It is just the appointment done by the President on the advice of Council of Ministers. The government indirectly appoints the Attorney General, free hand completely. So 1 is wrong. Number 2, one of the qualifications for being appointed as the Attorney General is that the person must have been a judge of High Court for at least 5 years, or an advocate of a High Court for 10 years, or an eminent jurist in the opinion of the President. Now, as far as the Attorney General is concerned, Attorney General should have the same qualification as that of a Supreme Court judge, meaning of course you will be a citizen of India. Then what else? Judge of High Court for at least 5 years, or advocate in the High Court for at least 10 years, or an eminent jurist, right? Somebody who's an expert in the field of law is a jurist. Jurist does not mean a judge. Jurist means somebody who is an expert in the field of law. Yes, so these are actually the qualifications to become a Supreme Court judge, hence perfect. So 2 is correct. So which of the statements is or are correct? B. 2 only. Moving on to the next question. Third schedule of the Indian Constitution provides for forms of oath or affirmations for whom among the following? So third schedule contains oath for the ministers. Ministers at the central level, at the state level. All the ministers. Ministers who are cabinet ministers also. Ministers who are ministers of state also. Every minister's oath is mentioned there. Apart from it, all the people who are legislators, meaning people who are MPs, MLAs, MLCs. Also candidates, those who are going to contest elections, candidates, their oath is also mentioned there. Apart from it, the oath of Supreme Court judges, oath of High Court judges, and the oath of CAG. Who is a CAG? Comptroller and Auditor General of India, CAG. So let's check now. Union ministers, yes, oath is mentioned. President, no. The president's oath is mentioned in a separate article, Article 60. VP's oath is also mentioned in a separate article, Article 69. And governor's oath is also mentioned in a separate article, Article 159. Judges of Supreme Court, yes, of course. So 1 and 3. C is the right answer. By the way, mind you, when it comes to the salaries and emoluments, the salary of the president, the governor, and the VP, this is mentioned in the second schedule. Okay, VP by virtue of them being the presiding officer of the Rajya Sabha. Then the union minister's salary is not mentioned in the second schedule. Okay, so please keep a note of this. Moving on to the next question, which of the following statements is correct? As per the constitution, the tenure of Rajya Sabha members is 6 years. Tenure of Rajya Sabha members is 6 years. As per the constitution, in the last few years, we have seen this statement a lot in the examination. So they'll ask you, they'll give you a fact, it might be correct. But the point is it mentioned in the constitution or not? That's the real challenge. So sadly, we all know that this fact is correct. But is it mentioned in the constitution? No. This is mentioned under section 154 of RPA 1951. Wrong. The minimum number of ministers in the Council of Ministers at the center must be 12. Is that the case? We all know that we have a maximum limit. There is an upper limit. How many ministers can you have? Maximum 15% of the total strength of the lower house. In the states also, at the central level also. Is there any minimum? Yes. Not for center, sadly. No. Not for center, but for the states. In the states, because some states might have very few MLAs in the lower house, right? 32, right? 40, 60, etc. In those states, we need to have at least 12 ministers. So minimum 12, but maximum cannot exceed 15%. So for states under Article 164, yes, the lower limit of 12 is set, not at the central level. Again, wrong. Number 3, it is mandatory for the person to be an ordinary resident of the state to be eligible for governor's nomination. Absolutely correct. To legislative assembly. Here is the trap. Everything was correct except this assembly part. There is no governor's nomination for the assembly. The governor's nomination is for the legislative council. But yes, this fact then would have been correct, because in case you want to become eligible for governor's nomination, I hope you remember that in the state legislative councils, 1/3 members are elected by the MLAs, 1/3 members are elected by the local body members, then 1/12 by teachers of 3 years standing, 1/12 by graduates. The remaining 1/6 are nominated by the governor, and these people must be ordinary residents of the state. But sadly, it's not for the assembly but for the council. So this is also wrong. Hence, D has to be the right answer. Let's read the statement. There is no ground mentioned in the constitution for the removal of the vice president. Yes or no? I mean, we have the ground mentioned for the president, right? Article 61, violation of the constitution. We have ground mentioned for the Supreme Court judges removal. The removal of High Court judges. What's the ground? Proved misbehavior or incapacity. Is there no ground mentioned for the VP's removal? That's absolutely correct. Article 67B just gives us the procedure to be followed. What's the reason? Nothing is mentioned. Maybe you say, he's not smiling enough. Remove him. Simple. Any reason. Of course, the reason has to be logical, rational, and genuine, but it's not specified in the constitution. So D is the right answer. Next question. Statement 1. The governors of states in India are mostly outsiders and do not belong to the state in which they hold the office. Yes or no? That's true actually. If you observe, there's been a pattern. Governors are always outsiders. Always outsiders. Why? Let's see statement 2 first. This practice is mentioned in the constitution and was added to keep the governor free from local politics. Actually, the logic is correct. This basically was used only to ensure that the governors don't get involved in local politics. Outsiders have no interest in local politics. And you can search for your state's governor and you will find that he or she is always an outsider. In fact, in 1983, a commission was formed which gave its report finally till 1988 called the Sarkaria Commission, chaired by one Mr. Sarkaria. He was the former Supreme Court judge, Justice Ranjit Singh Sarkaria. Anyway, so Justice Sarkaria's commission also said the same thing. Advice, recommendation that governors should be outsiders. In fact, we have been following this even prior to that. And there has just been one case, one instance, at least a known instance, where somebody who belonged to the state was made the governor for the state. I think it was Venkat Vishwanath back in 1960s, late 1960s in Kerala, who was from Kerala but served as an IAS officer in the MP cadre, but later on became the governor in Kerala. Beyond that, this has always been followed. Small problem. This is an example of convention, tradition, custom, a practice. It is not mentioned anywhere. Nowhere in the constitution at least. So statement 2 is incorrect. 1 is correct. So statement 1 is correct, but statement 2 is factually incorrect. Right answer is C. Also, to tell you frankly, if you come across such questions, assertion, reason questions, statement type questions, it is more likely, in most cases, at least as far as polity questions have come in the past, you will find that either statement 1 is factually wrong or statement 2 is factually wrong. This happens in most cases, right? Just a way to solve the questions also. Okay, moving on to the next question. Which of the following are discretionary powers of the governors in India? Discretionary powers of governors in India. Okay. Special responsibility with respect to law and order in the state of Nagaland. Yes, of course. Article 371 capital A. We have seen once a mains question also on this topic back in 2013. So yes, discretionary power of governor. Special responsibility for peace and ensuring the social and economic advancement of different sections of the population of Sikkim. That's also correct. Article 371 capital F. Clause G mentions this provision. Correct. And declaring that no act of parliament shall apply in respect of religious or social practices of the Mizos in Mizoram. This is actually mentioned under Article 371G, but there is a small problem. This is not the power of the governor, but the state legislature, right? So 3 is wrong. This means 1 and 2 only. A is the right answer. Moving on to the next question. A 36 years old person who is a citizen of India is qualified for election as a member of the Lok Sabha and does not hold any office of profit. Okay. Constitutionally, this person is qualified for which of the following other offices? 36 years old, meaning above 35. So he is eligible to be either the president or the governor or the VP. Does not hold office of profit, great, again eligible for president, governor, VP, and is qualified for election as a member of Lok Sabha. Qualified meaning eligible for being an MP of Lok Sabha. This criteria is meant for the president only. Governors, this criteria is not there. And for VP, constitutionally, the VP should be eligible to be an MP in the Rajya Sabha, not the Lok Sabha. So constitutionally speaking, VPs are out. It's the president and the governors. So 1 and 2 only. A is the right answer. Just remember, though in reality or in practice there is no difference. What is the criteria to be an MP in the Lok Sabha? The same criteria of being a citizen, right? Apart from the age factor that is there. This election as a member of Lok Sabha, one very important criteria is that you have to also be what? You have to also have your name in the voter list of any Lok Sabha constituency across the country. Now, till 2003, if you wanted to be an MP in the Rajya Sabha from any state, your name should have been in the voter list of that state. This no longer is a criteria, right? So now if you want to be an MP, that is since 2003 onwards, if you want to be an MP in the Rajya Sabha, let's say from Karnataka, your name can be in the voter list in Tamil Nadu and you can still be an MP representing the interest of Karnataka in the Rajya Sabha. Nirmala Sitharaman, classic example. Or your name can be in the voter list in Delhi and you can still represent the interest of Rajasthan in the Rajya Sabha. Sonia Gandhi. So this is now open and the same, but constitutionally there is still a difference, right? The language is still different for the VP and the president. So 1 and 2, the right answer. Next question. With reference to the President of India, which one of the following statements is not correct? Not correct. More than 5 former vice presidents of India were later elected as the president. It's a very challenging factual question. B. Oath of the president is administered by the Chief Justice of India. C. Both the president and the VP can resign from their office by giving resignation in writing to each other. And D. No candidate has been elected unopposed in the presidential elections till date. Now, of course, this question is slightly challenging. The first and last options are challenging. I'll tell you something. Firstly, second one is correct, right? Oath of president is administered by the Chief Justice of India. And third is also correct because the president will address his resignation to the VP and the VP will address his or submit the resignation to the President of India is correct. Now, as far as the last one is concerned, this is actually incorrect. Why? Because in 1977, Neelam Sanjeev Reddy did get elected unopposed because 37 people, around 37-38 people had filed the nomination and all the nomination forms were rejected. Only his was accepted and he got elected unopposed, right? So this is the right answer. And we have seen in total 6 VPs who have later on become the presidents of India. So 6 VPs have turned out to be the presidents later on. Okay. So this is also correct. Sometimes you might have some factual questions thrown here and there. Of course, if at any point of time you come to a situation where you have eliminated two and you have to choose between two, please go for it. Mathematically speaking also, of course, you are at an advantage if you have just two options to choose from. The benefit is higher, the loss is lesser. But this only should be used when you are very sure that the options you have eliminated are not the correct ones. Don't eliminate the right one only. I hope you have seen enough KBC to realize that people sometimes do these things as well. So please don't do that. Next question. Who among the following are appointed by the President on the advice of the Council of Ministers? Chairman and members of Finance Commission, yes or no? Yes, of course. That's true. Chairman and members of Election Commission, right? Of course not. Till recently this was the case, but you know very well, the Anup Barnwal case 2023, where the Supreme Court said that till the Parliament makes a law, every appointment of what? Every appointment of the election commissioners must be done by the President on the recommendation of a committee comprising of PM, LOP Lok Sabha, and the Chief Justice of India. Sadly, a modification was made and a law was passed with respect to the appointment, condition of service, etc., where this fellow has been replaced with a cabinet minister, right? But even now we have a committee to appoint or recommend for the appointment, and the committee also comprises of leader of opposition in the Lok Sabha. So 2 is wrong, 1 is correct. Number 3, of course, Attorney General and the Solicitor General of India is also correct. 1 and 3 only. C is the right answer. Moving on to the next question. Which of the following statements is or are correct with reference to the ordinance making power of the governors of the state? Ordinance making power of the governors of the state. So ordinance, which article comprises of this ordinance? We know very well ordinance is under article 123 for the president and 213 for the governor, right? So first one, it is a discretionary power. Is ordinance making or promulgating an ordinance a discretionary power? Not really. It's not a discretionary power. You have to always follow the advice of Council of Ministers. So 1 is wrong. Number 2, in case of bicameral legislature, ordinance can be promulgated when the state legislative council is not in session. So ideally, especially for the states, because a lot of states don't have 2 houses. There are only 6 states which have a legislative council. Which 6 states? Andhra Pradesh, Bihar, of course, Maharashtra, Karnataka, then UP and Telangana. Now, beyond these 6 states, all other states do not have a functioning council. Now, in those states, if the assembly is not there, there is a recess, then of course the governor can promulgate the ordinances. But what about these states? What if the assembly is not there but the council is functioning? Even then the ordinance can be promulgated. Why? The idea is that if either house is not there, then bills cannot be passed, because to pass the bills we need the assent of or approval of both the houses. Yes, we know councils are completely useless. They cannot prevent the passage of bills. They can only delay the passage of bills. But still, if we have a bicameral legislature, bicameral meaning we have 2 separate houses, then ordinance can be promulgated when assembly or council, either of them is not in session. So 2 is correct. Number 3, it is wider than the legislative power of the state legislature. Now, how can this be the case? In the simple concept is that ordinances are temporary laws. So why do we have this provision? We have this provision to ensure that in case there is an emergency or some exigency where we want to urgently make a law, we cannot wait for the legislators to come, sessions to convene, then the government can make a temporary law and get it approved within 6 weeks of the reassembly of the House. Now the problem here is the ordinance is just a replacement for a bill. Ultimately, when the ordinance is promulgated and the House is come back to meet, this ordinance has to be placed in front of the state legislature. Yes or no? It has to be placed and you have to get it passed. So, on the topics on which the state legislature has the power to make laws are the same topics on which the government has the power to make temporary laws, right? So it cannot be wider than the state legislature's power. It has to be the same. So 3 is wrong. So how many statements are correct? We know the answer. Only 1 is correct. Moving on to the next question. In the context of Indian polity, consider the following principles. Responsible government at the center and the state. Responsible government at the center and the state. Now see, that's actually a part of the parliamentary system. Always remember that the parliamentary system has a very interesting concept. And what is that concept? The concept is that 2 things. Number 1, we want a responsible and accountable form of government. And number 2, the executive is a part of legislature. And of course, the fact that the head of government is the real head, not the head of state. So, you have the concept of nominal head as well as a real head. Secondly, as I said, responsible government at center and states. Yes or no? Yes. Article 75 clause 3 talks about this very statement, that the Council of Ministers are collectively responsible to the House of People. Similarly, we have Article 164 clause 2 says the same thing, that the Council of Ministers are collectively responsible to the State Assembly. So yes, that's there. Number 2, executive being a part of legislature. Yes, that's also very important. See, at any point of time, anyone who is otherwise qualified to be a member of the House can become a minister. You need not be a member of the House while you become or while you're appointed as a minister. But ultimately within 6 months, you must become a member of the House. Elected or nominated, that does not matter. But you have to become the member of the House, right? So that is why we say that ultimately executive has to be a part of legislature. After all, ministers, are ministers not MPs? Yes, they're also MPs. That is why this is a diagram that you draw, that this is the legislature, and in this legislature only you have some MPs who are executive also, part of government. That's also there. In fact, you can see this under Article 75 clause 5, or at the state level Article 164 clause 4. Parliamentary sovereignty and judicial supremacy. Okay. So how many of these principles are embedded in the parliamentary form of government practice in India? See, parliamentary sovereignty is not in India. Why? Because in our country, constitution is supreme. Constitution is supreme. Whether it's the parliament or the judiciary or the legislature or the executive, everybody is bound by this supreme constitution. The constitution acts as a restraint on any organ's supremacy. So it's neither the parliament which is supreme in the country, nor do we have a judicial supremacy, right? So 1 and 2. Only 2 of these principles are practiced in India in the parliamentary form of government that we have. Okay. Next, which of the following statements about governors of states in India is correct as per the constitution? See, whenever you get this phrase, you have to be extremely alert. Not just factually, you also have to be very, very sure whether there is any possibility of this fact being mentioned in the constitution or not. See, there is no expectation from you to know the exact article. Frankly, for most aspirants, the big challenge is I am not able to, I cannot remember articles. In most cases, you're not supposed to. You're not required to. There is absolutely no need. Now, some articles are very, very important. Now, not just as an aspirant, as an informed citizen of this country, you should know what is Article 21, right to life, or Article 19, Clause 1, Subclause A, the speech and expression. These are important. Otherwise, not really. And if some article has been in the news a lot, let's say Uniform Civil Code, Article 44, then it is understandable. Otherwise, not really important. But you should be able to at least decipher whether some fact is a constitutional provision or some statutory provision or just a matter of practice, right? So here, as per the constitution, they act as chancellors of all the universities in the state. We all know governors are the chancellors of state universities. But is it mentioned in the constitution? Not really, because recently we have seen a lot of state governments or state assemblies trying to pass bills to remove the governor from this post. This comes from various state laws. States have their own laws where governors act as chancellors, right? But it is not a provision of the constitution. How can the state government ever bring about any change in the constitution? I hope you are aware that amending the constitution, such bills cannot be introduced in the state legislature. Such bills can be brought only at the central level. So one is wrong, or A is wrong. A bill passed by the state legislature on a subject in the concurrent list that violates a central law on the same subject can be declared valid with their assent. Is that the case? No, there are two aspects to it. Number one, we all know there are three lists. So, union list, where the center has the exclusive power to make laws. Ignore it. State list, where normally states make laws, normally because there are situations where the center can make laws on state list subjects. That's possible. Ignore it. We'll discuss a question from it tomorrow. Third is a concurrent list, where we know that both the center and states can make laws. The point is, if a central law or a state law conflicts or comes into conflict with a central law, we know that central law prevails. Overriding power. My point is, can a state make a law knowing very well that it is violating a central law on the concurrent list subject and still the law is allowed to continue? It can be done. This is what is mentioned under Article 254. And I'll tell you why it has been in news recently. Do you or have you heard of this issue going on in one state? Anti-NEET bill, Tamil Nadu. So NEET examinations, this is technical education. It is a concurrent list subject. Center has made a law for it. But Tamil Nadu government wants itself to be exempted from the NEET examinations. It has passed a bill. This bill eventually has gone to the center. Why? Because under Article 254, if the state tries to make a law on a concurrent list subject which is repugnant to a central law on the same subject, the president can give his permission and the law can prevail. President can give permission, not the governor, right? So it is not the governor's power, but the president's authority. When I say the president, please don't feel it is his or her power. It's the power of the central government, the Council of Ministers. See, they can use their clemency powers against sentence by court martials only with the prior permission of the president. Clemency power. Does the governor have clemency power? Yes, of course. Governors have clemency powers. Which article is it? Please tell me. It's Article 161, similar to the clemency power of the President, Article 72. Now, there are two major differences. One, of course, is that the statement is wrong. Why? Because court martials, military courts, sentences by military courts the governor has no such control over use of clemency powers here. This is wrong. Second is that the governor cannot pardon a death sentence. Just to clarify on it, a couple of years back there's a huge controversy, not a controversy, some newspaper wrote an article on it, that the governors can now pardon death sentences. And that's a very wrong interpretation of what has been happening. Governors cannot pardon death sentences. What the governors can do is they can commute a death sentence. But once somebody was given a death sentence and this fellow's death sentence has been commuted, let's say it has been commuted to a life imprisonment. Now this fellow is supposed to be in jail till the natural end of his life. Now in this situation, he can also apply for remission, meaning reducing the period of punishment. He can apply for remission to the governor also. He can apply for it to the state government also, right? Now, if you apply for remission to the state government, let me tell you something. State government cannot reduce your punishment to less than 14 years. That is why in movies they always show 14 years. Life term jail means 14 years, because normally what happens is when you are given life term, after 14 years you become eligible to be let off and your entire life term is reduced to 14 years, but not below 14 years. The question which was there in the court was, is this limitation also applicable on the governor? Is the governor also bound by the same limitation which is mentioned in the CRPC? The Supreme Court said no. In fact, if there is somebody who was given death sentence, today death sentence has been announced. This fellow approaches the governor. Governor commutes his death sentence to a life imprisonment. Let's say tomorrow. Day after tomorrow, the person can again approach governor and say, sir, please pardon my or reduce my punishment, life sentence to 1 day only. It can be done. This minimum 14 years criteria is not some kind of a limitation on the governor, right? This is a CRPC provision. And Article 161 is a constitutional provision. This was the criteria. So even now, governors cannot pardon a death sentence. They can only commute a death sentence. Some difference between the pardoning powers of the president and the governors. This means what? None of the statements are correct. Right answer is D, none of the above. Next question. Consider the following constitutional dignitaries: Chairman UPSC, Comptroller and Auditor General, Chief Election Commissioner and State Election Commissioner. See, the question says how many of the above can be removed in the same manner as Supreme Court judge. What is the Supreme Court judge's removal like? This removal, of course, we follow a procedure called Judges Inquiry Act 1968, but primarily Article 124 Clause 4 and Clause 5 deal with the provisions for removal of Supreme Court judge. And here the removal is by the Parliament. Voting in the Parliament. What kind of majority? Special majority. Mind you, the same majority required to amend the Constitution. 2/3 present and voting. More than 50% total strength of the House. Okay. So this is the majority required. Whichever is higher, that number of people are required. It's a very difficult process to remove the judges. Of course, independence of judiciary. That's the beauty. Constitutionally speaking, there are a lot of provisions to ensure independence of judges. On day 3, we'll discuss a couple of questions from that. So which other people are or can be removed in the same manner, meaning which other posts have been given a similar kind of independence? Of course, CAG. It's mentioned there, right? Article 148. Of course, the appointment of CAG is a challenge because the CAG is appointed by the President of India, right? Meaning the central government. But the removal in like manner, like grounds as Supreme Court judge. Article 148, ensuring the independence of the CAG. Chief Election Commissioner, yes. absolutely correct. If you refer to Article 324, Clause 5, then the boss of the ECI, the chief, he or she is removed in the same manner as Supreme Court judge. Now, what about the other election commissioners? That we cannot say anything because there is nothing mentioned there, apart from the fact that the other ECs can be removed on the recommendation of the chief election commissioner. And that is a big loophole. But CEC, we have a security. State election commissioners. Now, this is again a constitutional body, Article 243, capital K. Mind you, this body is different from the ECI. Don't correlate those bodies. SEC, what is the task of SEC? SEC is there in every state. What is the task? SEC's task is to conduct the elections for panchayats and municipalities. Okay. And very important, the SEC is appointed by the governor but cannot be removed by the state. The removal is in the same manner as a High Court judge, which is the same as that of the Supreme Court judge. Okay. So all these people are removed in the same manner. What about chairman of UPSC? See, Dr. Ambedkar has said that there are 4 pillars of the Indian Constitution: the Supreme Court, the ECI, the CAG, and of course your body, UPSC. Sadly for UPSC, we don't see the same kind of autonomy given in the Constitution. The chairman of UPSC is not removed in the same manner as Supreme Court judge. No parliamentary voting is required. These people are removed by the president after a Supreme Court inquiry. So, on the receipt of complaint against any member, including chairperson, the president will ask the Supreme Court that Supreme Court, please conduct inquiry. Look at this misbehavior or incapacity allegation. Please look into it. The Supreme Court will perform its own in-house activity of inquiring into the complaint. If the Supreme Court finds the allegation to be true, it will give its report that yes, President, remove this fellow, and the fellow is removed. No voting. So this is not correct. So how many? We know very well. C, only 3. This is the right answer. One more question on removal. Consider the following dignitaries: members of SPSC, members of CVC, members of ECI, members of CIC. How many of the above can be removed by the president after Supreme Court inquiry? So as I said, there are 2 ways to remove people. I have discussed one. What is that? One I have discussed is the way when we remove people through parliamentary voting, right? So that's one procedure, very simple and easy to understand. Second is Supreme Court's inquiry. Now, Central Vigilance Commission members removed like this. CIC members removed like this. NHRC, Human Rights Commission members removed like this. Lokpal members removed like this. Though there is an added point there that if you want to remove a member of Lokpal, 100 MPs have to give a complaint signed by at least 100 MPs. But eventually the procedure is the same. Supreme Court inquiry, no need of any parliamentary voting. Apart from it, the members of tribunals, CAT, etc., same kind of procedure. That is Supreme Court inquiry. What about the members of UPSC? Yes, of course, we have just seen that. So what about SPSC members? Now you would say, sir, but since SPSC is for the state, then maybe the High Court conducts inquiry and removes, and the governor removes. No. For the members of SPSC also, the Supreme Court conducts the inquiry and the president removes the members. Okay, that's how it is done. So members of SPSC, members of CVC, members of CIC, yes, of course, but not ECI members, because we do not actually know what is the process to remove the members of Election Commission. In fact, in the Anup Barnwal case 2023, Anup Barnwal 2023, the Supreme Court had told the government that government, please come up with a process to remove the other commissioners. I mean, you are giving so much of security of tenure to the CEC. But what about the other ECs? The government took no attention or paid no attention to it. Nothing has been done on that. So as of now, how to remove the ECI members? On the recommendation of the Chief Election Commissioner. Is the recommendation binding? We don't know. What's the procedure like? We don't know. What's the criteria? We don't know. In fact, to think of it, if you want to remove the ECI members, a very simple tool would be, don't remove members, remove the post only. Why? Because how many members will be there in the Election Commission? ECI comprises of a Chief Election Commissioner and such other election commissioners as the President may decide. So this X number, X is not the X you are thinking of, this X is a variable, meaning how many members of EC? It can be 1, 2, 3, 100, it can be 0 also. In fact, till 1989 it was 0 only. The ECI was a single member body, the Chief Election Commissioner. In 1989, V.S. Sehgal and S.S. Dhanua became the election commissioners. So as of now, this X is 2, meaning there are 2 ECs. This can be made 0 also. So in that way, you can remove the members by removing their post itself. But the process to remove members, that's not mentioned anywhere. So this is wrong. Right answer is C. Again, only 3. Next question. Consider the following statements. The Indian Parliament comprises of Lok Sabha, Rajya Sabha and the President. Yes or no? Is that correct? The Indian Parliament, does it comprise of the President also? In fact, when the new Parliament complex was being inaugurated, the big question being asked by all the opposition parties was that, as per Article 79, the President is a part of the Parliament and he or she is not being called to inaugurate the new Parliament complex. Violation of the Constitution is happening. Anyway, so this brings us to a point that Article 79 says that the Indian Parliament comprises of the House of People, the Council of States, as well as the President. So one is correct. Similarly, the state legislature as per Article 168 comprises of the governor, comprises of the state legislative assembly, and in those states which have a council also. So the state legislature does not include governor. This is wrong. It includes the governor. And number 3, as per the Constitution, the maximum permissible strength in the Rajya Sabha is 250. Yes, but currently, how many do we have? We have currently 245 members, 233 coming from states and UTs, and 12 members are nominated by the President. So how many statements are correct? We know very well what's the right answer. 1 and 3 are correct. 2 statements are correct. B. Next question. Consider the following resolutions. Impeachment of the President. Creation of All India Services. Removal of the Deputy Chairman of Rajya Sabha. Abolition of a Legislative Council. How many of the above provisions are mentioned in the Constitution? So again, easy provisions. Number 1, impeachment. Yes, it is mentioned. Impeachment of the President is mentioned under Article 61, right? This article is important. I'd request all of you to read the article also, because it has lot of elements to it, lot of information, like how many MPs are required to raise the notice, right? And then what is a voting like, 2/3 of what, right? Present and voting or total strength, etc. So we need to know this. Creation of All India Services, is it mentioned in the Constitution? Yes, of course, Article 312, right? It is mentioned in the Constitution. We know very well that Rajya Sabha can authorize the Parliament to create a new All India Service. All India Service Act 1951 will be modified, and we can create a new All India service. So as of now, we have only 3 All India services. Which are those 3? The IAS, which most of you want to join. The IPS, which some of you want to join to harass other people. Indian Police Service. And the Indian Forest Services. Not the Foreign Service. Foreign Service is a central government service. Okay? It is a Group A service under Government of India, central government. Right? So it's not an All India service. Because of course, the topic of foreign policy is a union list subject. Removal of Deputy Chairman of Rajya Sabha. Yes, of course, these provisions for removal of the presiding officer, deputy presiding officers, they're all mentioned in the constitution. Mind you, just one small question. What kind of majority is required to remove these people? The presiding and deputy presiding officers? The majority required is an effective majority. Please always remember, in case you want to remove the what? Presiding or the deputy presiding officers, effective majority is required. Okay, that means more than 50% of all the then members of the house, all the then members. So this is also correct. Abolition of Legislative Council. Yes, in fact, we have seen a mains question a few years back on this topic. That is the creation and abolition of councils. A mains question was asked on this, explaining the entire process. Article 169 talks about creating or abolishing a council. So how do you create a council? Very simple and easy to create a council or abolish a council. So let's say today maybe Rajasthan wants to create a council, or say UP wants to abolish a council. So the State Legislative Assembly will initiate a proposal with a special majority. Special majority is required. That is the same majority needed to amend the constitution in the State Assembly only. Once it is approved, then it is sent to the Parliament, and then Parliament will approve it by law. By law meaning what? Simple majority. At any point of time in the constitution, if you find this phrase mentioned by law, it means simple majority. And once the Parliament has approved it, then the respective state government can issue a notification and create a council if it is not there, or abolish a council if it is there. So that's also correct. So D, all 4 is the right answer. Next question, one more question on ordinances. So let's look at it. Every ordinance promulgated by the President must be tabled within 6 months of the assembly of the House before it ceases to operate. Fair enough. The power to promulgate ordinances is the discretionary power of the President, and no ordinance was promulgated under the Prime Ministership of Pandit Nehru. Okay, so ordinances, we know very well, Article 123, the legislative power of the President. Classic example of violation of separation of powers, because here we give the executive a temporary but a power to make laws, promulgate ordinances. So every ordinance that is promulgated must be tabled within how many months? 6 months or 6 weeks? 6 weeks and not months. Please don't be confused. 6 weeks of the reassembly. Okay, so one is wrong. Then the power to promulgate ordinances is the discretionary power. I think we have discussed this earlier as well. This is not a discretionary power. Promulgating ordinances is the power of the government, right? So the President is bound by the advice of the government. Sadly, can't use it on his own. Number 3, no ordinance was promulgated. Now, this is not possible. In fact, though we have seen misuse of ordinances a lot in our country, in fact, even in the first 12-15 years of Nehruvian government, over 60 ordinances were promulgated. In fact, till date, around 750 ordinances have been promulgated in the country. In the recent 2-3 years, the use has come down. but every government has loved using ordinances, right? Especially the states. In fact, the two most famous or infamous judgments, the DC Vadva case of 1987 and the Krishna Kumar Singh case of 2017, they both relate to the misuse of ordinance by states only, right? The state of Bihar. So that's there. So of course, under the Prime Ministership of Pandit Nehru also, we had over 60 ordinances promulgated, 66 to be exact, I believe. That's there. So how many statements are correct? D. None of the statements are correct. Next question. Consider the following statements. Nominated members of the House are not debarred from being appointed as a minister. Okay. And to be the Prime Minister, the person has to be a member of Lok Sabha only within 6 months from the date of his appointment as the Prime Minister. Oh, interesting. Let's begin with a question. In case you want to be a minister or the Prime Minister, first, should you be an MP of Lok Sabha only, or either house is okay? Either house is okay. You can be an MP of Lok Sabha or Rajya Sabha. You can be an elected MP or a nominated MP also. It does not really matter. You have to be a member of the House. So, nominated members of the House are not debarred. Of course, they are not debarred. They can also become the what? Ministers, including Prime Minister. And number two, now, I think we have just discussed it in the past that any person who is otherwise qualified to be a member of the House, right? He or she can be made what? Any minister or the Prime Minister, but for a maximum period of 6 months. Within those 6 months, you must become a member of the House. Of any House. Why only Lok Sabha? Not just Lok Sabha. You can be a member of Lok Sabha or Rajya Sabha. Right? In fact, on this concept, we have seen a movie also by Shankar Nayak. Right? So that is the same concept, one day chief minister. Is that really possible? Yes, it's possible. In fact, we have a provision for it in the constitution. Article 75 clause 5 for the center and 164 clause 4 for the states. So 2 is wrong because to be the PM, the person has to be a member of any house within 6 months. Okay. So which of the statements is incorrect? So we just have to be a bit cautious of this point. Incorrect. Right answer is B. 2 only. Then consider the following statements. Even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold office. Is that so? Yes, of course. If the Lok Sabha gets dissolved, you might say, sir, then how can they still be ministers? I mean, they have to be because we cannot have a vacuum in the country. In case Lok Sabha gets dissolved and there is some delay in the elections or the results, then who will govern the country in that small time frame? Will we have no Prime Minister? That could be a problem. So to prevent any kind of vacuum, that is very important. To prevent any kind of vacuum, we ensure that there is somebody at the top. So they will continue to hold office even beyond the period after the Lok Sabha is dissolved. So 1 is correct. In fact, it is the same for the president also in case required, for the speakers also if it is required. Okay. That's there. Number 2. The VPs administered the oaths by the Chief Justice of India or any other person appointed by CJI in that behalf. The oath to the Vice President is not administered by the CJI. The oath is administered by the President of India or any other person appointed by the President on that behalf. So it's not CJI, it's the President who administers oath to the Vice President. Mind you, to the President, the oath is administered by the CJI, but not to the VP. So 2 is wrong. Number 3, the removal of the VP in Lok Sabha requires simple majority. Interesting. So removal of VP is a very important topic Article 67 clause B. Now there is no set criteria or reason or ground for removal of VP in the constitution, but process is mentioned. And what's the process? Number one, the removal of VP can be initiated only in the Rajya Sabha. Such a resolution can be moved only in the Rajya Sabha. Point one. Number two, in the Rajya Sabha, you have to get it passed by an effective majority, meaning the majority of all the then members of the house. How do you find this majority? You take the total strength of the house and you subtract from it any vacant seats. Vacancy, not absent people. Vacancy, let's say there are 245 MPs in Rajya Sabha. Let's say there is a bus which is going to Goa with 20 MPs and the bus crashes and all the MPs die. I'm not saying let's hope, I'm saying let's say it happens. In that situation, those 20 seats are vacant. Now, if you are an MP of Rajya Sabha and don't go on a particular day to attend the sitting, you are absent. Seat is not vacant. So we subtract vacancy. Whatever number comes is called the effective strength. This is all the then members. More than half is what is called effective majority. Okay. Once it is approved by the Rajya Sabha, it is sent to Lok Sabha. In the Lok Sabha, yes, it requires what kind of majority? Simple majority. The removal of VP in the Lok Sabha requires a simple majority, right? So, yes, third statement is correct. First statement is correct. This means what? Right answer is C. Only 2. And let's look at the last question for today. Which of the following is or are correct regarding the removal of the vice president? He can be impeached only on the charge of violation of the constitution. I think we have discussed now enough on this point that this criteria, the ground, the reason is not mentioned in the constitution. And number 2, on removal of the president, while the VP becomes the acting president, the Chief Justice of India takes charge as the vice president for the remaining tenure. Interesting. Let's observe. So, if at all the president dies, who becomes the acting president? The VP. Mind you, the VP becomes the acting president. It's not America. It's not USA where the VP continues to be the president for the remainder tenure. He or she becomes the president only for maximum 6 months. Yes, of course, this fellow can contest for the election of the president. That's allowed. But within 6 months, elections have to be conducted to appoint or elect a new president. Now, this is what is mentioned in the constitution. In 1969, it so happened that we had neither the vice president nor the president because of the death of Dr. Zakir Hussain. So in that situation, what happened? Both posts vacant, and then we had to make a law which was called the President Discharge of Functions Act 1969. And according to the law, the Chief Justice, in case these two seats are both absent, the CJI becomes the acting president of the country. Acting president. Now, when the VP becomes the president, the VP seat is vacant. Now you might say, then sir, who takes over that seat? Nobody. It's okay. A VP has no special role to play apart from one very important role. Article 64, Article 89, what do they say? The VP is the ex officio chairperson of which house? Rajya Sabha. So if VP becomes the president, he or she cannot preside over the Rajya Sabha. What happens there? So there, don't worry, we already have a person called a deputy chairperson who is a member of the house elected from amongst the members of the house. Just like how the speaker is elected. That fellow will take over this role for a temporary period. So that's the only important role of the VP. So we don't really need a VP if VP seat is vacant, because we already have a person who takes care of the functions which the VP is expected to perform as the presiding officer of Rajya Sabha. that task is done. So on the removal of the president, while the VP acts as the president, the Chief Justice of India takes charge as a VP. That is not required. So this is wrong. Both statements are wrong. This means right answer is what? D. Neither 1 nor 2. This brings us to an end of our discussion for today. Tomorrow we'll be discussing questions from legislature. So if you can practice and revise legislature for today, that will be great. Topics from parliament, state legislatures as well as parliamentary committees will be covered tomorrow, including anti-defection law. That's also a part of parliament as a topic itself. And on day 3, we'll have questions from judiciary. For more details, refer to the schedule at the beginning of the session. Right? That's it. We'll meet tomorrow. Till then, that's all for me. Jai Hind.